All right, I want to introduce my guests today. One is Ross Kramer, criminal defense attorney, and I'm going to throw to you about this burglar who fell into the grease pit and was there for 2 days. What do you think of that?
Not all criminals are master criminals, and I think that's a case where that might not have been the best thought-out plan. And it sounds like in the end everything worked out because he got out safe, and I'm sure he'll be spending some time in the local jail thinking about it.
That is a heck of a story. Thank you, Anthony, for those stories on Top Crimes. So we're going to return. We are playing back testimony, and this is the case in Florida versus Denise Williams. Convoluted set of facts, but the witness we're going to go back to is Kathy, now Thomas. It was Winchester. It was Winchester because she was married at one point in time to Brian Winchester. Now, Brian is the one who took a deal and testified in this case, saying that he actually pushed the victim overboard and shot him in the face, but then it was done in conspiracy with Denise Williams, who was the wife of Mr. Williams, who is the one that was pushed overboard and killed. We're going to go to her direct testimony. Now, you may have watched that testimony about the four of them going on a trip and thought, so what? What's the relevance? Here's the relevance. There are allegations that have been made by the state that affairs were rampant in this case, and that the Brian Winchester, who was the person who actually killed Denise Williams' husband, they were all having affairs, and he claims that Denise Williams, he and Kathy were having affairs with each other. So they're talking about a trip, and later there's some photos. I'd like to bring it back to Ross Kramer, one of my guests, but we also have joining us Jennifer Schuster, trial attorney. Jennifer, thank you so much for being here today. And I'd like to ask you first, Jennifer, what's the relevance or importance to a jury of hearing all of the sordid details about trips and affairs amongst these four individuals?
Sure. Well, thanks for having me, Ashley. I think it just goes to this whole convoluted, twisted web that existed among these people since they were in high school, and then now we're in the year 2000. And just the fact that she's saying that she felt like she was a third wheel in the presence of her own husband, who's out with their friend. So I just think it goes to show that there were just all these sordid details and weird things happening.
And I understand, and Ross, I'd like to ask you, I understand that the defense said in opening, hey, there's no proof of any kind of relationship between Brian Winchester and Denise Williams. So does that make this more relevant testimony to show that, yes, there was?
Well, I think this is relevant testimony either way, because I think this goes to the motive here. And motive is not an element they have to prove, but it's very influential to a jury. She said she felt like a third wheel. There was a fourth wheel here that, this defendant may have wanted to get rid of, and, the cooperator here may have wanted to get rid of. And I think the convoluted relationship really speaks to why this may have happened, and I think it's going to be powerful for the jury.
And just another quick question, do you think that the relationship between all four of these individuals, two married couples that started back in high school, they've known each other for a long time, the families know each other, does that become an important piece for a jury to understand all that in considering a conviction of Denise?
Well, absolutely. In a case like this, juries can convict on a story, on a narrative, and if it goes back years, I think it's important for the prosecution to tell that story in order to give the jury the background to understand what happened at that moment when this person was killed.
All right, so hang on. Now we're going to go back to even more exciting testimony, and this is about any conversations that Kathy Winchester, now Thomas, actually had with Denise Williams. Let's hear what she has to say. All right, so again, that's Kathy, who was married at the time to Brian Winchester. He's the one that states that he did murder and shot the victim in this case in the face. So let me return to Jennifer Schuster, our trial attorney, and ask you this. Her testimony was, Denise, the defendant, said to give a message to Brian, I'm not talking. So what? What does that message mean to you?
Well, it suggests some kind of a cover-up, right? She's asking her friend to do her a favor and conceal some sort of evidence. That's the suggestion here. And so, yeah, it looks like Denise is in a bad spot. And her friend, ultimately, we know, became an informant. And so it just goes to show that Denise had something to hide.
Okay, so she might have had something to hide, but they have charged her 3 different charges, one of which is a murder charge. And we know from the evidence presented so far that Winchester says, look, I took him out in the boat, I pushed him overboard, and when he was hanging onto a tree, I shot him in the face. How can the defendant, Denise Williams, be charged with murder when she didn't act? She didn't do anything.
Yeah, well, I think that's going to be an argument on behalf of the defense. But, I mean, the law is you don't need to be the one who actually pulls the trigger to be charged with murder. So she can absolutely still be held culpable, even though she isn't the one who actually pulled the trigger. If the evidence shows that she participated in the agreement, in the planning of this, she can still be found guilty.
All right, so Ross, do you agree by her saying, I'm not talking, give Brian that message? Is that enough to attribute an action to her for her to be found guilty of the murder?
Well, no, that statement itself goes more to the cover-up, I think. You know, it goes to, it's a classic conspiracy statement, cooperator statement. You know, I'm not cooperating, pass this along, I'm not a snitch, I'm not working with the police. It certainly gives flavor and context to what was going on, but I don't think that in itself is going to be able to allow a jury to convict for murder here.
All right, so if that's not enough, we're going to go to a break, but come back because we're going to hear a recording that was made by Kathy of Denise, the defendant in this case. We'll be back after this short break. So here's what's interesting. That was, again, an audio recording that was between Kathy Thomas, the witness, and between the defendant in this case, Denise Williams. But Denise never admits anything on this. So, Ross, is this helpful to the prosecution?
I'm really confused as to what we just heard and why this was put in by the prosecutors, because I think it actually has two downsides here. First of all, on the actual recording, when the defendant is speaking, I think she sounds credibly enough like, what are you talking about, she says, you know. So why was this introduced in the first place substantively? And number two, what this recording shows is how the prosecution's witness lies, pretends to cry, makes up stories, acts upset very, very naturally. This is somebody that the prosecution is putting on the stand here as their witness to tell the jury she's credible, and they're hearing a tape where this woman lies and makes up stories like it's second nature here. I think this is a very strange decision by the prosecutors.
All right, so Jennifer, do you agree with Ross, or do you have any different perspective or take on why they played this recording in the first place?
Well, it's my understanding that she's acting as an informant, so it's expected that she'll put on somewhat of an act. And I don't think that alone diminishes her credibility, but I agree to the extent that we're not really hearing anything from Denise Williams that shows that she knew what was going on. Now, I personally think that her answers seem a little measured. If your friend is telling you she knows what happened to your ex-husband, I think there would be more urgency. But that's something for the jury to assess.
And I did feel the same, because it was as if she was digging for information, Denise was, when she asked questions back, because she said, admitted what? Who planned it? Marcus planned it? I planned it? Like wanting to get more information out of Kathy. We'll see what a jury does with that recording when they have to actually deliberate and render a verdict in this case. So before we take a short break, I want to remind you of what's coming up. It's a really exciting segment here on Law and Crime, Law and Mediaite with Colby Hall. This is where law meets politics, and he'll be giving us some great information after this short break, so please come back and join us. So remember, the voice that you hear in the recording that sounds so upset is the voice of Kathy Thomas. That is the witness who's on the stand that you've been seeing on your screen. Ross, I've got to throw it to you because you mentioned her demeanor as a witness versus how upset she sounds in the recording. What would your argument be as defense attorney about that?
As a defense attorney, I would really like this testimony. She's sitting there looking very angry at everybody in the courtroom. And on this recording, she's showing what an excellent actor she is and what an excellent liar she is. She's managing to call up these tears, sound very credible about how upset she is about this totally made-up situation. And when a jury hears a professional law enforcement source getting on a phone and making controlled recordings and acting and giving false stories, they understand that that's part of their job. But when a prosecution witness gets on the stand and gives this kind of performance, to show that they're very, very comfortable liars, I think it makes it very hard for a jury to know who's telling the truth here, who's acting, who has a bias, who has a motive to make up a story, who's angry at somebody else, and that's why they're testifying. I think it's a very convoluted case, and I think this witness and this controlled phone call make it all the more convoluted.
All right, so Jennifer, let me ask your opinion about that testimony that we just listened to, and I also want to ask you this. Is there any type of entrapment to be argued by saying, look, this witness was acting distressed and trying to entrap her into saying something she shouldn't?
Yeah, well, when it comes to the demeanor of this witness, I think that probably some of those tears are genuine. Yes, she's lying, but on the other hand, she has experienced significant trauma. So maybe she's crying about something else, but I think she's not necessarily this great actor. I think she's probably under some serious stress, and as a result of that, the jury can understand why she would be crying. I'm not really sure what they're doing, though, with this tape, because the conversation, especially at this point, seems really unfocused. They're talking about her marriage. I think maybe there's some value to the extent that Denise isn't asking, well, tell me what happened to Brian. I mean, Denise seems remarkably calm and measured. When it comes to the entrapment, I mean, there are very specific elements to entrapment. Law enforcement is allowed to engage in certain techniques to elicit information. So I don't think here this is a case of entrapment because, again, there's very specific elements there, and I just don't think they're pushing it quite that far here.
All right, so we're going to take a short break, but please come back and join us for more of the testimony in this case. You know, listening to Kathy on that recording, I wonder if she's acting the way she is, upset, asking the questions simply to try to get Denise to tell her things and admit to things that she did involving her in the murder of her husband. Let me ask you, Ross, what do you think, and why is it we talked about there's a difference between entrapment and the legal definition versus somebody calling a friend and trying them to get to confess to something?
Yeah, so what entrapment is when law enforcement tries to get somebody to commit a crime that they otherwise wouldn't be predisposed to do. So the classic example is when a cop comes up to someone and tries to sell them drugs, and they say, no, I don't do drugs. And they say, follow them down the street and say, come on, man, you know, I need this money. It's for my sick wife. No, I don't want to do it. And they bother them and call them. And finally, somebody says, okay, here's my money. I'll take it, whatever you have. That's something that this person would not have otherwise been predisposed to do, but law enforcement has overcome their will and has basically forced them or tricked them to do something that they otherwise wouldn't have done in committing a crime. So that's not what's happening here. This is not committing a crime. This is using a trick or a subterfuge to try to get someone to admit that they committed a crime. So it's not entrapment, and it's a legitimate law enforcement technique that's frequently used either by law enforcement agents or by cooperators making phone calls or wearing body wires.
Okay, good. So that's our distinction between the two. We're going to continue to listen to the recording and see what else, if anything, Denise Williams has said. Well, there it is. Listening to this recording, I haven't yet heard anything, Jennifer, that makes much of a deal of anything Denise Williams has said to indicate she was a principal in the murder of her husband. So the prosecution made a big deal about this recording. What's the big deal in this recording to you?
I agree with you. It's tough to tell. I mean, I'm not sure what the state is doing here with at least this portion of the recording. I mean, I'm listening to two girlfriends talk about one of their problems in their marriage. I mean, obviously it's related to this extraordinary event, but essentially she's giving her friend advice about whether or not to talk to her second husband. And we're not really hearing anything from Denise Williams that shows that she participated in the planning of this crime or participated in any way. You
know, and to me, if anything, we're hearing Kathy upset because her new husband, Rocky, may learn all kinds of things about her sordid past, including affairs with men, women, inside of marriage, outside of marriage. So maybe that's the reason she's upset. We don't really know. Quick question. In this case, the defendant did not testify, and the defense is rested, prosecution's rested. Is that good or bad?
Oh, for the defendant not to testify?
Yes.
My goodness, I think it's a no-brainer that she wouldn't testify. They don't have the burden of proof, and she would have been skewered on cross-examination, especially given all the convoluted facts and the sordid relationships here.
All right, so let me give everybody an update. The jury has been sent home for the day. Lawyers are there to talk about the jury instructions with the court. We understand that tomorrow morning they will begin and finish closing arguments, jury instructions, so that the jury can deliberate. Law and Crime will certainly be covering any of that live when it does begin. We are going to take a short break and resume testimony. Please join us in just a couple of minutes. All right, Ross, wait. Hold the phone. I am so bothered as a judge. I understand in Florida it's the judge's discretion to let the jury ask questions or not, but I don't get it. The jury's there to deliberate, to determine if there's reasonable doubt or not. The prosecution has to put on their case. To me, by the jury asking questions, now they're prosecuting the case.
I have never been involved in a trial where the jury got to ask questions, but I have been involved in cases where the judge, on his own initiative, has decided to ask questions of a witness when he felt that there was something missing that a jury would want to hear. I don't know how I feel about it, but I don't think it's a terrible idea, because how many times have we all had as trial lawyers, the end of a case, you get a chance to talk to the jury after a verdict, and the jury says, why didn't you ask this? Like, why didn't you ask this question? Why didn't you talk about this topic? This might have changed my mind. I don't think it favors one side or the other in this kind of case. I think it certainly presents questions to witnesses who may not be prepared for those questions, because a prosecutor has scripted a direct and worked with a witness, and all of a sudden questions are coming from left field. It's a very different procedure, but I don't know that I dislike it.
And so, Jennifer, let me throw to you and ask you, to me the red flag is, what if it's a question that's not at all relevant, and then you've been asked this question, and for appeals purposes it creates some issues with the evidence that comes in? What do you know about it or think about this practice?
Right. Well, I know that the jurors don't just ask the questions. They have to write them down, submit them to the judge, and both lawyers have an opportunity to review and object to the questions. So the questions actually may never be asked if the judge actually sustains the objections. So to that end, I think it's very problematic, because the jurors could infer, hey, why wasn't my question asked? Somebody's got something to hide. Because the jurors are not lawyers. They may not understand the rules of evidence and why the question could not be asked. And so I think then the jury can interpret that, misinterpret that, and have some bias moving forward.
And did you notice the judge even said, when the witness said, I don't understand, he said, well, I think that's what the jury was asking about. I think they wanted to know. So now it's not only the jury saying, here's a question, here's the judge saying, well, I think this is what they meant. I'm just astounded. Do you know whether or not judges frequently allow juries to do this in Florida?
Based on my research, there are only, I think, fewer than a dozen states across the country that allow for this. But like you said, it's in the judge's discretion. So it's going to vary from courtroom to courtroom. And I don't know what the history of this judge is, or why perhaps he thought in this case it was relevant. But it's certainly a very interesting procedure.
It is an interesting procedure. So I need to get off of that topic and move back to more of the questions that the jury did ask. There are two more questions we're going to listen to now that Kathy was asked to answer. Well, you can see when Kathy Thomas answered those questions, she seemed to take a minute to really think about it. So, Ross, did you find her any more credible when she was answering those unscripted questions from the jury?
I think she seems fine. The problem I have with this case is the jury is going to be asked to unravel testimony from a whole host of witnesses, all who have motive to fabricate, who have antagonism towards different witnesses, towards the defendant, towards other witnesses here. They were all in romantic relationships with each other. A lot of time has passed. There's a lot of sour grapes between these witnesses that's developed over time. I mean, this is going to be a very, very difficult web for this jury to unravel and decide who's credible here and whose testimony they could believe as unbiased testimony about the important facts in the case.
All right, so we're going to share some breaking news Kathy has just shared with us from court, and that is right now the attorneys are with the judge discussing jury instructions in this case, and it is important to note that neither side has requested jury instructions for lesser included offenses. What does this mean? This means that the only charge the jury is going to have to decide is murder in the first. So that is the only thing they're going to consider, whether to convict or not murder in the first degree of Denise Williams. Let me ask you, Jennifer, what do you think of that? Hot off the press.
Yeah, well, I mean, that's like an all or nothing thing, right? If you don't convict on the greater charge, then she ends up walking. And so that's a good thing for the defense if they think that they are able to poke holes in the prosecution's case.
And so what do you think, Ross, from the prosecution's perspective? I certainly expected they would want to include lesser included, because in watching all the convoluted facts, credibility issues that my two experts have raised with us today, I would be concerned.
I agree. If I had this kind of case, I would have done that if I were them. But in a lot of cases, the prosecution doesn't want to risk the jury finding a lesser charge, what's called in a lot of the cases like a compromise verdict, where the jury is sure that they did something, but they can't all quite agree in the jury room, so 12 people have to agree unanimously here. So they agree that it's to use the second or third charge on the list instead of the top charge. And I guess what happened here was the prosecutors didn't want to risk that. They may think they have a much stronger case than, we do here.
Have you ever seen juries come back with the question to say, hey, is there any other charge we can consider in this case? If we can't agree on that one, is there any other charge we can think about?
Yeah, absolutely. I've seen juries come back with that. I've seen juries come back with dozens of notes explaining the element, asking for explanations on the elements of a charge, asking for the facts, asking for transcript portions to be read back. Juries are very conscientious, and juries really get it. I think any lawyer who underestimates the care and intelligence the juries put into these cases is making a mistake. I think in this case there's a chance they might do that, or they might just take it for granted that this is the only charge they have to consider, and we'll see which way they go.
And listen, seeing that the jury can't ask questions means they are certainly engaged in the trial and listening to the testimony. So that's all good for the jury and their deliberations. We're going to take a short break, and please come back. So here you heard one of the defense's other arguments, which is, hey, she wasn't a principal. She didn't do anything in this case. Brian Winchester is the one who took him out in the boat, pushed him overboard, and shot him in the face, killing him. She did nothing. Ross, what we've heard prosecution allege and say is, sure she did. She made sure that he went hunting with Brian so that he would then go on the trip and be murdered. What do you think of that position?
Well, look, that sounds like enough, even under the case law that this attorney is citing. And, both of these motions, sometimes you bring up motions and you're not confident that the judge is going to grant them at the time, but you're setting up appellate issues. If you think that your client may get convicted, you're setting up a situation where you properly objected to the jury charges that are going to go because you don't believe there was enough evidence to support the jury even considering it. You're setting up an appellate issue like the first argument. If there are inconsistent verdicts from a jury where they found one thing and another thing and they can't both be the case, you could argue to an appellate court. So these are important strategically, not just for this judge, but sometimes the motions at this stage of the case are to set up other avenues of attack if there's a conviction.
All right, Jennifer, do you agree as a trial attorney with Ross in the approach that as defense you want to put these motions out there, if nothing else, for the appellate record?
Yeah, absolutely. The defense is doing a good job at creating that record, which is critical at the appellate level. But an interesting legal question here is the agreement, or like Ross said, her orchestrating some of these meetings between Winchester and the ex-husband. Is that in fact enough? Is that an act? So I'm curious to see what the judge is going to decide here.
And I think what's important to note is the only evidence that she actually did that is Winchester's testimony. And he did get immunity and a potential good deal in another case and not having to serve life in order to provide his testimony. So he's the only one saying that she was actually involved in it. Stay tuned. This is a trial you do not want to miss. We're going to take a short break and be right back. For me, it's really easy to get caught up in our justice system and wanting to see those who have committed a crime and it's proven beyond a reasonable doubt, certainly found guilty by a jury. But what we sometimes forget are the victims' families and the grief that they have and they go through. Jennifer, let me ask, was that a threat? You just heard testimony from the victim's mother who said, look, the defendant in this case told me I don't ever want to hear his name again, basically stop pursuing a criminal investigation, and if you do, you're never going to see your granddaughter.
Yeah, absolutely, it's a threat. I mean, what greater threat could somebody pose to a grandparent that she'll never see her grandchild again. And it certainly shows that Denise had reason to hide something. She didn't want this case exposed. She didn't want it investigated, and she directly told that to her mother-in-law.
All right, so devil's advocate, Ross, is there any chance that Denise felt like, hey, listen, the authorities told us what happened, and this, I'm angry, I'm grieving, I've lost my husband, and I can't handle any more about this. I'm trying to handle my grief.
Well, look, this is why you have two sides trying to make arguments to a jury. Every fact that comes out, it's the defendant's responsibility to put a spin on it, and it's the prosecution's responsibility to put their spin on it. The defense lawyers are going to argue that. I think this was pretty good testimony for a prosecutor here. I think this is somebody who, appears credible on a stand, somebody who's outside all these tangled relationships and says, I had this very bizarre run-in with the defendant where she told me not to go to law enforcement. And I said, what if that was your daughter in the lake? Wouldn't you want to go forward with it? This just doesn't make any sense to me. I think this is a lot better testimony for the prosecution than the one we saw right before.
Yeah, absolutely. So Cheryl Williams is still on the stand. Let's listen to some more of her testimony. It's as if we have a crystal ball. So defense, sure enough, is cross-examining her, Cheryl Williams, the mother in this case, and saying, hey, couldn't it have been that Denise Williams was just grieving? So let me ask you, Jennifer, how would you cross-examine? I mean, this witness garners sympathy. I just feel heartbroken for her that she's lost her son. How would you effectively cross-examination a witness like this?
Well, I think the defense is taking the right approach in that, his demeanor is not particularly aggressive. But he's, like you said, trying to lock her into this argument that it makes sense that Denise would want closure. But does it really make sense given the amount of time that's elapsed? They're talking about an incident that happened in 2001, and this murder happened in 2000. And is it really believable that Denise would need that closure only after a year? I mean, we all know investigations are pending for much, much longer than that. Perhaps it would be more believable if they were having this conversation in 2015, but not 2001, in my opinion.
All right. And Ross, let me ask you, so the questions were very long that defense asked and laid out all of a big scenario. Was that an effective format of the questions, in your opinion, as a defense attorney, to play Monday night quarterback?
You know what they always say, if something works and you get the answer you want to get, then it was a good question. I would not have asked those questions the way that this defense attorney phrased them. They were very open-ended questions, and if you had a witness who had an agenda or was a little more sharp on the attack, she would have turned that around and said, well, yes, if somebody was innocent, maybe they would have said that, but these are the reasons why, I didn't believe her, and I don't think she's innocent. Everything she said was also consistent with guilt. These are, open-ended questions, and you usually want to stay away from those kind of questions on cross-examination here. But they worked out. I mean, he got the answers he was looking for, and the grandmother, or the mother in this case, really played into his theory and sort of went along with it.
That's right. So the last answer that we heard her give was, could you believe her innocence based on her answers or what she was saying? And the mother said, well, yes. One other thing to note in the testimony is that since 2005, she has not seen her granddaughter. Just as the defendant, Denise Williams, said, you're not going to see your granddaughter again if you pursue this criminal investigation. She has not seen her since 2005. We are going to continue looking at this case in depth. Please come back after this short break. All right, Jennifer, this is what's interesting to me. Defense on cross-examination just asked this witness, isn't it true that your mother thought Mike was still alive, held out all hope he was going to walk back through the door? Why is it appropriate for defense to ask him that versus asking her as the mother when she was actually testifying?
Well, it's not drawing an objection, and so it's relevant because he wants this witness to admit that the Denise was justified essentially in cutting off the grandmother from the granddaughter. And I don't agree with the defense's strategy because I think it's such an outrageous argument. He's drawing this argument out, and yes, the witness is not really pushing back, but I just don't think the underlying argument is a good one.
And so I did like that we heard the judge say you're not going to argue with the witness. In your experience, do judges tend to step in if there's an argument going on and protect witnesses?
Yeah, absolutely. I mean, the defense lawyer can push it to some extent, but he can't engage in too much of an argument. I mean, the very nature of cross-examination is that it's an argument, but you can't engage in certain behavior that's inappropriate. And so that's quite common to see that with a judge stepping in like that.
All right. So, Ross, any other thoughts that you have in terms of the testimony? These two witnesses, it's pretty compelling, very sympathetic. Is a jury going to be sympathetic to their testimony?
Yeah, I thought these were good witnesses, and I agree with Jennifer. If I was the defense lawyer, I would have stayed away from a lot of the cross-examination here. I would have taken it very easy, and in closing statements, I would have summed it up and said, you know what this is. This was a grieving family that wanted to move on. I wouldn't rely on these witnesses to try to say that.
All right. Just a reminder to our viewers, closing arguments are expected in the morning along with the jury instructions and deliberation. Law and Crime will cover that live. Jennifer, thank you so much for being with us. I understand that you'll be signing off, but as always, we appreciate your expert analysis of these trials. And this one's an exciting one. Just in one word, do you think there'll be a conviction or not?
I'm thinking not, but
right.
Be interesting to see. I'll stay tuned. Thanks for having me, Ashley.
Thank you for being on, and we're going to take a break and come back to Law and Crime for more trial coverage.